Mr. Kamal Trivedi, Learned Advocate General, Ms. Manisha Love Kumar, Learned Government Leader, Mr. Mitesh Amin, Learned Public Prosecutor, Mr. Devang Vyas, Learned Additional Solicitor General, Mr. Yatin Oza, President, Gujarat High Court Advocates Association, Mr. H.S. Patel, Chairman, Bar Council of Gujarat, distinguished senior advocates, learned state law officers, learned members of the bar, officers and staff of the registry, ladies and gentlemen, we have gathered here this evening to commemorate the ushering of a new era in the history of the High Court of Gujarat. And as this new page of commencing live streaming of court proceedings and release of the relevant rules adds to the book of time, enthusiasm is high, coupled with even higher expectations from the public. On behalf of all my sister and brother judges and the High Court of Gujarat, I extend a warm welcome to everyone present in this virtual function and also everyone watching this program live. I heartily welcome Honorable the Chief Justice of India for being a part of this path-breaking event as the chief guest. His Lordship took over his current role in the midst of the second wave of the pandemic of COVID-19. Due to his proactive efforts, His Lordship has been able to stage a turnaround towards a situation of present normalcy. The role of the Supreme Court during this time has been a point of appreciation, wherein not only my Lord, the Chief Justice of India, but also Honorable Dr. Justice Chandrachud and Honorable Mr. Justice Shah have spearheaded the efforts to help bring relief to the victims all through the country. Judiciary has historically been known for its stern decisions for the welfare of the people, even if such decisions are less popular. Our Chief Justice has followed the axiom by cancelling events which otherwise could turn super spreaders. My Lord has raised alarm at the poor digital connectivity in rural and tribal areas, which acts as a major roadblock in the dream of inclusive justice. I also welcome Honorable Dr. Justice D.Y. Chandrachud, Chairman E-Committee Supreme Court, as guest of honor to this function. It was only on His Lordship's persuasion that the live streaming has seen the light of the day. But for his support and encouragement, it would not have been possible for the Gujarat High Court to start live streaming. I have had the good fortune of being one of his soldiers during his 2.5-year tenure as the Chief Justice of Allahabad High Court. I still address him as Chief. My apologies, my Lord. We also have with us Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India, our guide and mentor. His Lordship has been a part of several benches dealing with issues relating to the pandemic of COVID-19 and has been signatory to several pioneering judgments on vital issues. The High Court of Gujarat and the entire judiciary of the state of Gujarat cannot even dream of an event without the presence and blessings of His Lordship. There has been huge contribution of His Lordship in the growth and strengthening of the judiciary of the state of Gujarat. I welcome you, my Lord, with warmth and respect as a special guest for this function. 3 years since the judgment rendered by the Supreme Court in Swapnil Tripathi versus Supreme Court of India, the novel approach and vision of open courtrooms, unhindered by physical or economic barriers, bears fruition. Today, under the august guidance of my lords and in the presence of such a distinguished gathering, we inaugurate the live streaming of the court proceedings of the High Court of Gujarat. As sunlight dispels darkness, as knowledge dispels ignorance, so would live streaming of court proceedings offer transparency and accountability to court proceedings. Over the centuries, decades and years, shrouded in mystery, it gave many an opportunity to offer a strong critique to the working of courts, fastening delays occasioned at the doorstep of the judiciary. With a view to offer real-time virtual access to courtroom proceedings as it unfolds, enabling the most affected constituent in the system of justice dispensation, the common man, to view firsthand adjudication process, form informed opinions on court functioning, and increase the reach of the courts to the public. Justice Chandrachud, in his opinion in the Swapnil Tripathi judgment, made reference to sunlight, which is an oft-quoted phrase. May I take this opportunity to quote a few lines only. Para 18H. I quote, above all, sunlight is the best disinfectant. Live streaming as an extension of the principle of open courts will ensure that the interface between a court hearing with virtual reality will result in the dissemination of information in the widest possible sense, imparting transparency and accountability to the judicial process. I unquote. 1st of May 2020, the constraints of the pandemic compelled us to symbolically commemorate the 60th year of the establishment of the High Court of Gujarat on the virtual platform through live streaming. Since then, strong and conflicting views were being exchanged for and against the proposition of open courtrooms through live streaming. One morning, I received a call, a suggestion. Time has come to use technology to uplift the judicial process. Anchored by my Lord Justice Chandrachud's strong recommendations, we decided to take the plunge, determined to face the currents of change. The rest is history. As a pilot project, the first court opened its doors on 26 October 2020. The response was overwhelming. Inspired by the vision for courtrooms going live, shorn of physical barriers, the live streaming rules committee and the technical team in the High Court Registry strived hard to frame the live streaming rules to remain in place till the E-Committee of the Supreme Court finalizes its rules to be uniformly adopted and emulated. Unanimous in their fervent commitment to serving the litigant in specific and the public in general, my brother and sister judges unanimously decided to open courtroom doors to live streaming. Ladies and gentlemen, let me be honest in saying that going live is a challenge in itself. It requires courage, confidence, and above all, conviction. I say with utmost commitment and humility at my command that I am proud of all my sister and brother judges who unanimously approved the rules to go live. I would like to use this opportunity to very briefly talk about the glory that this institution, High Court of Gujarat, has seen in the past, with the hope that years to come will see my fellow sister and brother judges and learned members of the bar raising this institution to newer and greater heights. The High Court of Gujarat has been first in many instances. They are countless. Time constraints do not permit such elaboration. On some other appropriate occasion, I will definitely elaborate. I feel proud to be heading this revered institution during this exciting time of digital and speedy justice, which only 2 years ago would have sounded like an oxymoron, as the churning wheels of law have been known to be tardy, albeit efficient. I also take this opportunity to speak briefly with my younger friends at the bar, as I would like to remind them that change is never easy. It is bound to cause inconvenience, but as the great sage Rafiki in The Lion King said, one can either run from it or learn from it. I hope our young fraternity will follow in the footsteps of our stalwarts, both from the bar and the bench, and will accept and exceed the expectations that the citizenry has from them and quickly adapt the new framework. They would rather learn from it and not run from it. I would be failing in my duty if the efforts and persuasion of my entire registry of the High Court, and in particular the technical team led by Registrar SCMS and ICT in arriving at this goal are not acknowledged, which I most humbly do. In the end, I'd like to express my gratitude to one and all for having spared time out for this function. I sincerely hope that the High Court of Gujarat is only the beginning, and our efforts here will have both a trickle-down effect within the state of Gujarat to district courts and a trickle-up effect across the country in various high courts. Thank you.
Thankful to my Lord. Now, a humble video presentation.
My lords, with permission of the august chair, this video of the initiatives of the High Court of Gujarat in the area of information and communication technology during the trying times of COVID-19 pandemic crisis is humbly presented to your lordships. My lords, upon adoption of video conferencing and email filing, to facilitate smooth joining to the VC hearing sessions, software-based automation to send advance VC links through SMS and email was developed in integration with the published cause list. Instant SMS call-out facility was developed for use by the court masters to issue SMS alerts to the advocates for joining VC hearing sessions. From the 15th of August 2020, e-filing facility as developed by Honourable the E-Committee of the Supreme Court of India was launched for select category of cases, while also establishing contactless physical filing counters. My lords, since the onslaught of the COVID-19 pandemic till now, against an inflow of 1,395 matters, 73,140 matters could be finally disposed of, which yielded case clearance rate of 72.85%. My lords, for facilitating smooth and seamless submission of requests for mentioning of matters, an online mentioning platform has been developed. An advocate or party in person registered for a particular matter can submit mentioning request online upon SMS OTP verification. VC links are sent instantly by the system to them for joining when the request is taken up by the concerned bench. My lords, email notifications for listing of matters and order judgment uploading were already being sent to all learned advocates. During the pandemic crisis, due to the challenges faced in physical reach to the premises, Honourable the ICT and E-Governance Committee headed by Honourable the Chief Justice, directed to give special emphasis to share maximum case updates through email notifications. Accordingly, automatic transmission of email notifications to learned advocates and parties in person on events like filing, registration, scrutiny, disposal, uploading of orders and judgments and process issuance have been developed and implemented. Digitally signed bail orders are automatically sent to the concerned subordinate court and the learned advocates. Email notifications upon caveat filing, caveat matching and progress of certified copies have proved to be real value addition to these services for the learned advocates. Now, the whole life cycle of a High Court case is covered with email notification on all events and updates in the case. My lords, as per the vision of Honourable the Chief Justice and guidance of Honourable Judges of the ICT and E-Governance Committee of the High Court, the push to emphasize the email-based services continue further, with implementation of email notifications for filing, registration, next date, disposal and order judgment uploading for all the subordinate courts of the state. My lords, we also take this opportunity to share with your lordships about a unique email facility already implemented for the judicial officers of Gujarat. All judicial officers get automatic email whenever any order is passed by the High Court of Gujarat upon any impugned order of the particular judicial officer. This facility is very popular amongst all judicial officers of the state. Another unique email-based initiative of our High Court for all the judicial officers is that all the orders and judgments passed and uploaded by the judicial officer are automatically sent to the official email address of that judicial officer. This immensely helps the judicial officer in automatically creating a repository of orders and judgments, with facility of searching on many criterion. Since launch of these email services for subordinate courts on the 2nd of October 2020, more than 50 lakh emails have been sent so far to the learned advocates practicing in the subordinate courts. To promote further the noble cause of access to justice, and even easier access to its information, a unique path-breaking litigant-centric service has been developed for all courts of the state, whereby anyone and everyone can follow any case to get current as well as further updates of the case till its disposal, through automatic emails sent by the system. This first of its kind service in the country, envisioned by Honourable the Chief Justice and implemented as per the guidance of Honourable the Judges of the ICT and E-Governance Committee, has been working like our instant virtual inquiry counter in these difficult times, with more than 5,000 cases of the High Court having been subscribed by more than 2,500 subscribers for automatic future updates. Other initiatives taken with the objective of ensuring alternate platform for instant information dissemination are a new display board telecast live on High Court YouTube channel and a Telegram channel for sharing circulars, miscellaneous notification, cause lists etc. Another visionary initiative spearheaded by Honourable the Chief Justice is experimental live streaming of proceedings of the Chief Justice's Court on YouTube, which is being formally inaugurated today by the august hands of your lordship, in presence of the distinguished dignitaries, including one of the great author of the landmark judgment, that ushered sunlight in the open court.
May I now request Honorable the Chief Justice of India to please release the live streaming rules of the High Court of Gujarat, titled as the Gujarat High Court Live Streaming of Court Proceeding Rules.
Now,
We are just click. Huh?
yes.
Over.
Obliged, my lord. May I now request your lordship to kindly inaugurate new web page of live streaming board of High Court of Gujarat. Grateful to Honorable the Chair. May I now request the special guest of this function, Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India, to please deliver his address.
Good evening to all of you. Honorable the Chief Justice of India, Justice N.V. RAMANA, my learned brother, Dr. D.Y. Chandrachud, Judge Supreme Court of India and Chairman E-Committee, Supreme Court of India, Chief Justice of Gujarat High Court, Justice Vikramnath, Justice J.B. Padiwala, Chairman Live Streaming Rules Committee, other brother and sister judges of the Gujarat High Court, Learned Advocate General Shri Kamal Trivedi, Ms. Manisha Laukumar, Learned Government Pleader Shri Mitesh Amin, Learned Public Prosecutor Shri Devang Vyas, Learned Additional Solicitor General of India Shri Yatin Oja, President Gujarat High Court Advocates Association, members of the Chairman and members of the Bar Council of Gujarat, Registrar General, Registrar IT and its entire team, members of the registry, senior advocates, learned senior advocates present, ladies and gentlemen present. First of all, I congratulate the Chief Justice of the Gujarat High Court and other brother and sister judges of the High Court for launching a live streaming of the court proceedings. As a pilot project, the court proceedings of the first court of the High Court of Gujarat started live streaming in spirit of the judgment of the Supreme Court in the case of Swapnil Tripathi, of which my learned brother, Dr. Justice D.Y. Chandrachud was also a party. In today's function, there will be release of the Gujarat High Court live streaming of Court Proceedings Rules 2021. The rules seem to be absolutely in the line with the observations and the suggestions made by the Supreme Court in its judgment in the case of Swapnil Tripathi. With the advancement in technology, one has to move ahead. One has to move with time and accept the change. I'm today very proud and happy that the Gujarat High Court has started and the live streaming of the court proceedings, and it seems the Gujarat High Court will be the first of this live streaming. I can say with proud and privilege that when Gujarat leads, correct, there is always a success, and always the Gujarat takes the lead. Right of access to justice flows from Article 20 of the Constitution of India. A litigant has a right to know what is happening in his matter in the court. As observed by the Supreme Court, live or online transmission of court proceedings will subserve the cause of access to justice. Our legal system subscribes to the principle of open justice as the live streaming of courtroom proceedings as it genesis in the principle of open justice. My learned brother, Dr. Justice Chandrachud, has in detail considered the benefits of live streaming of courtroom proceedings in the judgment in the case of Swapnil Tripathi, and has dealt with in extenso each and every aspect of live streaming or courtroom proceedings. I would like to refer to some of the observations made by my learned brother made in the said decision. Open justice is a long established principle of common law systems. It rests on a high pedestal in a liberal democracy as a sound and very scared part of the constitution of the country and the administration of justice. The principle underlying open justice is that, quote, justice should not only be done, but should manifestly and undoubtedly be seen to be done, unquote. Public must be able to enter any court to see that justice is being done in that court. Open courts ensure a check on the process of adjudication in judicial proceedings and public confidence in the judiciary and in the process of judicial decision, making it crucial for preserving the rule of law and to maintain the stability of the social fabric. The benefits of the live streaming of courtroom proceedings are narrated by my learned brother in the judgment in paragraph 107. Few are: a litigant is supposed to know how his case was put before the court by his advocate and how it has been dealt with. It will enhance the faith of a litigant in the judicial system and administration of justice. A large segment of the society rarely has an opportunity to attend the court proceedings due to constraints like poverty, illiteracy, distance, cost, and lack of awareness about court proceedings. Litigants have to depend on the information provided by the lawyers. By live streaming of the courtroom proceedings, there shall be transparency in the court proceedings, and it would enhance the accountability of the judicial institutions and of all those who participate in the judicial process. Lawyers are also part of the judicial process. Many a times, a litigant does not know the real reason for delay. Delay in the dispensation of justice is a matter of serious concern. Live streaming of court proceedings enables the members of the public to know of the causes of adjournments and the reasons why hearings are delayed. It will not only enhance the accountability and will have a transparency, but it will enhance the discipline in the court proceedings. Live streaming of the court proceedings may also enhance the knowledge of law also. I do not want to say more on the benefits of live streaming of the courtroom proceedings, as the author of the judgment in Swapnil Tripathi is with us. He will throw more light on the same. Live streaming of the courtroom proceedings was his dream, and it will come true today. Honorable the Chief Justice of India is also very keen and very much interested in timely justice and the transparency in the court proceedings. Transparency in the court proceedings and the timely access to justice is in his heart. I am thankful to both Chief Justice RAMANA and my learned brother Dr. Justice D.Y. Chandrachud to be part of today's launching program of the live streaming of court proceedings despite their busy schedule. While parting, I will only say one thing, that by live streaming of the courtroom proceedings, there will be transparency in the court proceedings and will ultimately help the common man litigant who as such for various reasons is unable to attend the court proceedings. It will enhance the access to justice and it will secure the administration of justice and the faith of the common man in the justice delivery system to which the courts are meant and established. Litigant and the people would have more confidence in the justice delivery system. Today is a great day for the entire justice delivery system and the judiciary, and it is a historical day so far as the court proceedings will be concerned and the justice delivery system is concerned. I am thankful to the Gujarat High Court for giving me this opportunity to be on this platform today on the launch of live streaming of the courtroom proceedings. Thank you. Jai Hind, Jai Jai Garvi Gujarat.
Thank you, Lordship, for this encouraging address. May I now request the guest of honor, Chairman of the E-Committee of the Supreme Court of India, Honorable Dr. Justice D.Y. Chandrachud, Judge Supreme Court of India, to deliver his address.
My Lord, the Honorable Chief Justice of India, Justice N.V. Ramana, my distinguished colleague and bench partner, Justice Mukesh Bhai Shah, Chief Justice Vikram Nath, judges of the High Court, the Advocate General, Government Pleader, Public Prosecutor, Mr. Yatin Oza, the President of the Gujarat High Court's Advocates Association, and all distinguished guests, ladies and gentlemen. Judgments, of course, can achieve milestones, as I believe Swapnil Tripathi did. I shouldn't say more about it since I was a party to the judgment and I shouldn't speak about myself and my written work. But despite the passage of time, there was no action on the ground. So I thought that what perhaps the judgment has not been able to achieve, which is its implementation, I can achieve by the use of my soft skills. And I picked up the phone and I spoke to the Chief Justice, Justice Vikram Nath, who has been a valued colleague of mine since our days together at the Allahabad High Court, to come and do something. And I was sure that Vikram, with his dynamic approach to administration, would be able to achieve something. And so soon enough, he responded to me that his court was going to go live. And he asked me whether I would take the burden of the different viewpoints on whether there should or should not be live streaming. And I told him that I'll stand by him. And that's how we gave the go ahead. And here we are today in less than a year, in 10 months, where this is being implemented now across in the Gujarat High Court. So I would begin by congratulating the Chief Justice, the judges of the ICT committee, all the other judges of the Gujarat High Court who have had the confidence and the courage to put their heads on the screen and to put their minds and their personalities on the screen. It's not a very easy thing for a judge to do because we are so used to being cloistered in our courtrooms. This is truly a new age that the Indian judiciary is moving into. I would also like to thank the staff of the registry of the High Court of Gujarat, because they are the backbone, the spine. Without them, this could not have been achieved. And I truly must compliment their efforts through the pandemic as well. We think of court proceedings as proceedings consisting of judges, of lawyers, and some court staff. But there is a wider interest of society in what happens in the court, irrespective of whether they have cases pending in the court or otherwise. It is this element of public interest which live streaming is intended to subserve. It adds to transparency. People actually get to know that judges are at work. That at 10:30 or 11, depending upon what time the courts begin, judges have put their heads down into their briefs and they are working every single part of the day. There are a lot of misconceptions about the functioning of the judiciary. And it's easy to target judges about the holidays which we have. But people don't realize the immensity of the work which judges do even when they have time off, including on the weekends. It will reduce cost for the litigants. Live streaming, I believe, has become a necessity in the pandemic as people cannot access court proceedings. They cannot travel. There have been lockdowns. But it will equally be essential when the pandemic subsides and normal court working returns, because I do believe that this is indeed the need of the hour. It will demystify court proceedings for all citizens to really convey to citizens the message that we are courts for the people, for the citizens. But equally, I must tell you that there must be a certain degree of responsibility on the part of the members of the bar in the context of live streaming. Because one of the apprehensions which was expressed was, would lawyers argue to the gallery instead of arguing the case before the court? I'm an optimist in human behavior. I do not subscribe to pessimistic or cynical views about the judicial system. And I do believe that the members of the bar are extraordinarily responsible, and they will use this opportunity to responsibly conduct this new process of conveying news, information, and views about the court to the wider society. I would also like to inform everybody here that Chief Justice Ramana, the Honourable Chief Justice of India, has been equally keen on live streaming. He has been constantly engaging with me as the chairperson of the E-Committee, asking questions, probing us, encouraging us. And I'm sure that what has begun as a new initiative by the Gujarat High Court will now become a countrywide feature. As Chief Justice Vikramnath said, it will trickle down and it will trickle horizontally and it will trickle up as well, I hope. I must tell you a little bit about the activities of the E-Committee in the next 5 minutes before I conclude. The E-Committee has realized that the stakeholders in the court system in adopting technology are the litigants and the members of the bar, of course, apart from the lawyers and the judges and the civil society. So we have conducted online training for the members of the bar because we do believe that all our initiatives, including e-filing, will not be successful unless we train members of the bar. So between May 2020 and May 2021, nearly 2.03 lakh advocates, judges, and court staff have benefited by the training. As on 28 May 2021, 30,781 advocates and advocate clerks and 4,000 advocate master trainers were trained by the E-Committee in coordination with the state judicial academies. And these trained master trainers will be training other advocates from the taluka to the district to the high court levels. One of our missions in the E-Committee is to be collaborative. We do not follow the top-down approach. We have involved the high courts in much of the work which we do, in fact, in all of the work which we do, and we have been transparent by uploading all our activities and documents on the new website of the E-Committee on the SUAS platform. We have framed model rules for video conferencing. 5 senior judges of the High Court framed these model rules. We circulated the rules of video conferencing across India. Most of the Chief Justices gave us valuable suggestions, and these have now been converted into model rules for live streaming. We have formulated model rules for e-filing. And we have also now formulated model rules for live streaming, which have been circulated not just to the high courts, but to civil society, so that we do want to elicit responses, criticisms, suggestions, so that we can improve for the better. During the period of the COVID-19 pandemic, from 24th March 2020 to 14 July 2021, 1 crore 60 lakh cases were registered all across India. During this period, 1 crore cases have been disposed of by our high courts and district judiciary. In the district judiciary in Gujarat, the cases which were registered during this period were 12.23 lakh cases, and 8,07,000 cases have been disposed of by the district judiciary in Gujarat, which is really a tremendous feat by the district judiciary because it is not shielded as the higher courts or the superior courts are. So we must compliment the work of the district judiciary in the state of Gujarat. I must share with you that the e-TAL electronic transaction aggregation and analysis layer of the Government of India, the e-court services have recorded more than 354.1 crore e-transactions during the pandemic. So you can imagine the reach of the e-courts project. 354 crore transactions have been recorded. We are in the process in the E-Committee of putting out a standard operating procedure for digitization of cases. 2,700 crore documents in all courts across India will be digitized. And we have constituted a committee which has framed a draft SOP, and we have already circulated the SOP to the high courts for their responses. As phase 2 of the e-courts project comes to an end, we have prepared a vision document for phase 3. The vision document for phase 3 was prepared by civil society experts from across different parts of the various sectors. And these have now been circulated to IITs, the high courts, national law universities, and Niti Aayog for their inputs and suggestions. I've recently constituted a subcommittee on preparing e-registers. So much of our time in the high courts is taken in manual preparation of registers in the district courts. The inspection which takes place by the high court administrative judges in the physical form. So we have proposed now to completely dispense with physical registers by substituting them with e-registers, and that work is going on in a very significant way. There is a committee which is working, which is being chaired by Justice Moushami Bhattacharya of the Calcutta High Court on preparing a blueprint for how we can use technology for the benefit of the marginalized, for women who are victims of gender violence, for the LGBTQ community, for the scheduled caste and scheduled tribes, for the other backward classes, for the marginalized sections of society. Let me tell you briefly about the virtual courts. Virtual courts are functioning in 9 states, in Delhi, Chennai, Pune, of course, in Maharashtra, Kerala, Karnataka, Nagpur in Maharashtra, Assam, Chhattisgarh, and Uttar Pradesh. In Delhi, the notice branch receives traffic challans for offenses captured by the CCTV cameras. Now, just to share with our audience the kind of reach of our virtual courts, the virtual courts where the work of almost 24 judges is being done by a single judge with the aid of technology, proceedings have been completed in 73.68 lakh cases so far. The total fine has been paid in 14.77 lakh cases, and 161 crores of rupees has been realized by way of fine. About 82,000 violators choose to contest their cases. We have almost all our cases today on the National Judicial Data Grid. To give you an estimate in terms of the statistics, 638 districts across India are now on the National Judicial Data Grid. 3,296 court complexes are on the NJDG. 7285 establishments are incorporated. And pending cases available on the National Judicial Data Grid are 3.89 crore pending cases. Data of 10.79 crore disposed of cases is available on the NJDG, and the total number of cases available on the NJDG is about 14.69 crore cases. Now, this is a mine of data. And the next step which I am proposing to adopt with the permission of the Honorable Chief Justice of India would be to train High Court judges, the Chief Justices, on the use which we can put to this data in the court management systems across the country. So these are some of our initiatives. A very recent initiative is the National Service and Tracking of Electronic Processes, NSTEP. As we all know, the bailiffs serving a defendant or serving a respondent is the most difficult thing, or serving summons in a criminal trial is the most difficult thing. So we have operated the NSTEP with the help of a smartphone, and the smartphone uses the GPS coordinates to serve the summons or the writ as the case may be, and it is tracked through the GPS device and uploaded on the server. The signature is taken in the electronic form with the coordinates on the GPS, and it is all uploaded onto the servers. Finally, I'll also like to mention about the e-filing portal which has been developed by the E-Committee. E-filing version 3.0 has now been unveiled. The E-Committee of the Supreme Court has designed the e-filing system. The e-filing system is a complete end-to-end solution developed for online filing of plaints, written statements, replies, and applications related to cases. Both civil and criminal cases can be filed across the country in a bilingual form, English as well as the language of that state or region, to reach a wider covering group of advocates and litigants. The advocates can register using the bar registration number. Litigants or clients can register using the mobile number and email ID. The e-filing system provides various services to members of the bar and to litigants: ready-made templates for drafting of pleadings, online submission of wakalats. E-signing enables the client to e-sign the document, online payment of court fee, online video recording of the oath, simultaneously filing of several applications across court complexes in one go. Portfolio management of all the cases of a lawyer is available on the e-filing module. The exclusive facility to add advocates, juniors, or colleagues who are members of the same chamber. And the dashboard gives a glance at a status of all the completed and pending activities related to cases in the portfolio, so that an advocate is able to get the entire universe of their cases through the e-filing module. So these are some of the recent initiatives of the E-Committee. I will conclude by thanking the Chief Justice, the members of the E-Committee, and all the judges for this unique venture. I'm sure that this will now be replicated in the rest of the country. And I'm so glad that Gujarat really has been at the forefront of initiating and unveiling this new initiative. It's a progressive state. It has a judiciary with a great deal of vision that we see every day when Justice M.R. Shah and I look up judgments and receive judgments from the Gujarat High Court. And I must say that we are impressed by the dedication and commitment of this court to the service of the nation and to the cause of justice to the citizens at large. Thank you very much, Chief Justice Vikramnath and all the judges. Namaste.
Grateful, my lord, for this enlightening address. May I now request the chief guest, Honorable the Chief Justice of India, Honorable SHRI Justice N.V. Ramana, to deliver the inaugural address.
Justice D.Y. Chandrachud, Chairman E-Committee, Supreme Court Judge, Justice M.R. Shah, the Supreme Court Judge, sister and brother judges, Justice Vikramnath, Chief Justice of Gujarat High Court, Justice Pardiwala, Chairman, Live Streaming Rules Committee, sister and brother judges of the Gujarat High Court, Mr. Kamal Trivedi, Advocate General, Ms. Manisha Lavkumar, Government Leader, Mr. Mitesh Amin, Public Prosecutor, Mr. Devang Vyas, Additional Solicitor General, Mr. Etin Oja, President of Gujarat High Court Advocates Association, Mr. H.S. Patil, Chairman, Bar Council of Gujarat, distinguished senior advocates, state law officers, members of the bar, media friends, ladies and gentlemen. Today marks an important day as we are observing the 101st birth anniversary of legendary Justice Y.V. Chandrachud, former Chief Justice of India. I pay my humble tributes to his memory. Democracy is all about the people. The people of India are bestowed with the right to know under the Constitution, which includes knowledge of the institutions that serve them. One way to further this right is to allow the people access to watch the proceedings of the institutions. The purpose is to keep the public informed. It is only on the backs of an informed citizenry that a representative democracy can survive and evolve. The constitutional courts of our country, the largest democratic republic in the world, are the guardians of the constitutional mandate. For public confidence and faith to reach new heights, it is imperative for us to widen the gates of justice. I say widen because traditionally the courts have always been open. Since their inception, from the filing of a plaint to the delivery of the judgment, every proceeding of the court is based on the idea of transparency. Hearing of cases have always taken place in the public courtrooms, with access being allowed not only to the lawyers but the litigants in a particular case, but also to the public. The only restrictions that were ever imposed were because of space and security considerations. Recently, the pandemic has forced us to impose new restrictions. However, the harshest realities of poverty, social inequality, lack of awareness, cost, distance, and time made it difficult for some of the population to actively attend court proceedings. Truth to be told, even after 74 years of independence, multiple incorrect notions still prevail in the minds of the public regarding the justice delivery system. These prevailing notions and misapprehensions ultimately hinder access to justice, as they may disinclination and people to seek redressal to their rights. It is high time for demystifying the justice delivery system in the country and furthering access through open courts. Access to justice will become a true reality when the litigant and interested parties get to witness, understand, and comprehend justice dispensation firsthand. It may be noted that not all cases may be of the interest of the public. People may want to follow the arguments of the lawyers and observations of the bench only in certain cases, such as those that involve constitutional importance or attract public attention. Currently, the public obtains information about court proceedings through the media. In effect, The information from the courts is being filtered by the agents of transmission. In the process, there is sometimes a transmission loss leading to misinterpretation of questions asked and observations made by the bench. Due to the absence of context, vested interests are eager to amplify these misinterpretations in order to embarrass or discredit the institution. It is this lack of direct access which gives space for misconceptions. The formalization of the live streaming of court proceedings is the best cure for the aforesaid malady. Live streaming of proceedings is crucial for dissemination of information, which is a sacrosanct aspect of Article 19. Through such direct access, the people get first-hand information about the entire proceedings and the opinion of the judges, leaving little room for any mischief. Although a step in the right direction, one must tread the path with caution. At times, live streamings of proceedings may become a double-edged sword. However, judges might feel the pressure of public scrutiny, which may ultimately result in a stressful environment that may not be conducive to justice dispensation. A judge must remember, even if justice commands standing up against the popular perception, he must do so out of his commitment to the oath he did under the Constitution. A judge cannot be swayed by popular opinion. Yes, with increased public gaze, he might become a subject of multiple debates that should never deter him from his duty to protect the right of one against the might of many. Always remember, as a repository of people's faith, a judge cannot afford to lose objectivity. Similarly, with the increasing access, lawyers should not go after publicity. Rather, they must ensure to put in all possible efforts to protect the best interests of his clients. They must always uphold and maintain the dignity of the profession. Another aspect that must be taken into consideration is the privacy of the parties involved and ensure the safety and security of the victims and witnesses. Therefore, it is imperative to carefully calibrate the rules governing such live streaming by keeping in view of the competing interests. I am extremely happy to note that the High Court of Gujarat has taken up this initiative to live stream court proceedings and have formalized the same through the institutional rules. The committee under the leadership of Brother Justice Chandrachud is playing a wonderful role in bringing all the courts on board to unleash the transparency revolution with the aid of modern technology. And just now, Brother Chandrachud has explained the activities which is taking place and how much hard work the computer committee, e-committees are working. As I have stated already, earlier launching access of online proceedings of the Supreme Court to the media, we are keen to start live proceedings at least for some of the courts in the Supreme Court. We are working out the logistics and working on the consensus of the full court. With the aid of modern technologies, I am given to understand that we can introduce this live streaming feature in a cost-effective manner without imposing much of a burden on the exchequer. On this occasion, I congratulate the Chief Justice Vikramnath, Justice Pardiwala, Chairman Live Streaming Rules Committee, and brother and sister judges of Gujarat High Court who have come forward to open up their courts for everyone to watch the justice delivery system in action. Live, unfiltered and unedited as envisioned by our founding fathers. I thank you, one and all, particularly the Chief Justice of Gujarat High Court, for giving this opportunity and inaugurating this wonderful project. Thank you. Namaskar.
Obliged to my Lord for the motivating and enriching address. May I now request Honorable Mr. Justice J.B. Pardiwala, Chairman, Live Streaming Rules Committee of the High Court, to kindly propose vote of thanks.
Honorable Mr. Justice N.V. Ramana, the Chief Justice of India, Honorable Dr. Justice Dhananjay Y. Chandrachud, Judge Supreme Court of India and Chairman E-Committee, Supreme Court of India, Honorable Mr. Justice M.R. Shah, Judge Supreme Court of India, my esteemed sister and brother judges, distinguished senior advocates and other members of the legal fraternity, ladies and gentlemen, it is my honor and pleasant duty to conclude this online event with a vote of thanks. Today's event reminds me of what Martin Luther King Jr. had said almost 6 decades back. I quote, "One of the great liabilities of history is that all too many people fail to remain awake through great periods of social change. Every society has its protectors of status quo and its fraternities of the indifferent who are notorious for sleeping through revolutions. Today, our very survival depends on our ability to stay awake, to adjust to new ideas, to remain vigilant, and to face the challenge of change." I unquote. Ladies and gentlemen, we are heading towards a big, big change for a better tomorrow. A law student, Swapnil Tripathi from the National Law University, Jodhpur, approached the Supreme Court with an inventive plea that the proceedings of the Supreme Court of India, especially the constitutional bench matters, are far more remote and inaccessible for the bright and meritorious law students whose learning experience is bereft of any practical exposure. A 3-judge bench accepted the plea that a publicized justice through live streaming would become extremely affordable, as it would bring the whole system virtually at the doorstep of the litigant or those wanting to observe the legal fraternity closely. One of our distinguished guests today, Honorable Dr. Justice Dhananjay Chandrachud, in his concurring judgment elaborated how live streaming would make the judiciary accountable and acceptable to those it is meant to serve, that is, the litigants. It reminds me of the words of Jerome Frank, an American legal philosopher. I quote, "Courts in a democracy do not belong to the lawyers or the judges. They belong to the people." And the message today of all the 3 distinguished guests is very clear. It belongs to the people. After the judgment in the case of Swapnil Tripathi, the High Court of Gujarat, I'm a part of it, was the first in the country to take the initiative under the able and visionary leadership of Honorable Mr. Justice Vikram Nath, Chief Justice of this High Court. It all started first with the live streaming of the court proceedings of Honorable the Chief Justice. And today, the dream has come true. All the courts are to go live from Monday. This major breakthrough or the venture is ultimately going to help the people at large. First, we are thankful to Honorable Mr. Justice N.V. Ramana, Chief Justice of India, for having given his consent to be the chief guest of today's inaugural function. My Lord, we are beholden to you not only for sparing your valuable time for today's function, but for all the encouragement, motivation, and guidance we have received from you to make this venture successful. My Lord's presence today meant a lot to this High Court and to the people of the state of Gujarat. We are equally thankful to Honorable Dr. Justice Dhananjay Chandrachud for being with us today in this inaugural function. My Lord, we are beholden to you in all respects. The High Court of Gujarat shall be looking forward to seek your guidance for all times to come to make this venture more and more beneficial and effective in the larger interests of one and all. Live streaming, as in the words of Justice Chandrachud, I quote, one pill for many ills, I unquote, is the synthesis of the wide spectrum of observations recorded by His Lordship in the judgment of Swapnil Tripathi. My Lord, your erudite ideas and vision has guided the High Court of Gujarat to achieve this distinction. We are also thankful to Honorable Mr. Justice M.R. Shah for having spared his time to join this online event. We are beholden to you, my Lord. Justice M.R. Shah is a very happy man today. He looks very happy, and why not? Sitting in the Supreme Court, His Lordship's parent High Court has made him a proud man. Finally, we owe gratitude to all of you who have joined us today and made this historic function a grand success. Before I conclude, I would like to quote John F. Kennedy. I quote, "As we express our gratitude, we must never forget that the highest appreciation is not to utter words, but to live by them." I unquote. May what we have initiated today live in the hearts of, I quote, we the people of India, I unquote, and we find in it value and fulfillment. Thank you. Jai Hind.